Welcome to the Virtual Center for the Study of the Constitution of the United States. The Executive Director of the Virtual Center is Dr. Bill O'Brien. He's also your host for this ongoing conversation. And here he is now, Dr. Bill O'Brien.
Thank you, Bob Kincaid, and welcome to today's program. I missed last week, and we had reruns, so I'm very, very glad to be back with you. Needless to say, I'm a little bit nervous. I don't know. I think I always told myself when I was teaching that it was always good to be a little bit nervous. When you become too complacent, you run into trouble. So I am a little bit nervous. I always want the program to be one that is worthy of the time that you take as a listener to listen in. And if you are so inclined to call, by all means, I would encourage you to do that. In fact, at the beginning today, I'm going to throw out a couple of things that I really do solicit your opinions and your ideas about a program that'll be starting in a couple of weeks. But before I do that, let me give you the basics. The phone number if you would indeed like to call, the phone number is area code 304-658-3333, and my email address is waobrien906@gmail.com. That's waobrien, O-B-R-I-E-N, 906, all one word, at gmail.com. And again, the phone number, 304-658-3333. We don't have when you miss a week, it's hard to build on or use what we did yesterday as a jump off because there was no yesterday. So I'm going to basically go back and try to recreate a mood, so to speak. But before I do that, I want to address an issue of a program that I'll be beginning in a couple of weeks, and I want your input if I can. A number of you have sent me emails and suggested things about developing a website and all that. We are in effect doing that. We're going to be doing that. And one of the reasons that I want the website is because I want it to contain a message board. I want the opportunity to be able to post these documents and these letters ahead of time so that you would get a chance to preview them or look at them before we talked about them on the air. And then if you did have questions or comments, you could make those comments or ask those questions in the time when the issue came up. And so I want the area I want the opportunity to post. So I want the website for that reason. It'll also have a chat room, and it'll give you an opportunity to email me during the program. And if I see the email, I can address it while we're on the air, rather than waiting until afterwards and reading the email and then having to wait until the next day to address a particular issue. So that's one of the reasons. But another reason, and that's the program I was referring to earlier, I had mentioned several weeks ago now that once the schools went back into session, and our local schools went back into session last Thursday, the 15th of August, then what we are going to do here locally in southern West Virginia is entertain a program where high school students in this county, that was really not a reflection comment, but it's a throat clearer comment. The high school students in our local county, there are 5 high schools in our county, are going to have the opportunity, juniors and seniors, to register for a 3-credit college class that I am calling Foundations of the American Republic. And it'll be based on the very, very same content that we've been dealing with here at the Virtual Center. And it will primarily be based on primary documents. One of the things that I proposed in the original proposal, which was accepted by the school board, is that we would not use the textbook, that this is going to be based principally on primary source materials, be it letters, documents, laws, Supreme Court decisions, or whatever. And that's why I want the opportunity to post, because I want to find a way, and this is where I'm asking for your input here at the Virtual Center. What I am asking for is your input on the best way to get these students to connect here at the Virtual Center to our afternoon program together. One of the areas, if I'm posting documents, then I can post documents for those students and have them go to our website and look at a particular document in preparation for a class or a session that we're going to have. That is one thing that I'm very intent upon. But also, I would like to give students the opportunity to engage me and each other and you as listeners at the Virtual Center on during our programs, during our afternoons together. And so I don't know how many students will register for this program. There's a potential for 50, 60, 70 students. I don't know that we'll get that many, but that's a possibility, because I'm not just looking for the 10 or 15% that know they're going to college. In fact, the ones I'm looking for principally are the students that aren't sure whether they could do college, even if they do choose to try to go. Basically, I'm proposing this course as much a skill class, a college prep class, in focusing on skills, as on the content itself. And so the course will run not just for the fall semester, but through the entire academic year up until May of 2014. And one of the things that I want to accomplish in the course is I want to teach students how to interpret primary sources. Basically, what I want to do, I hope I can do, is teach students how to read critically, how to ask questions of what they read, how to penetrate documents, how to read between the lines, how to scope out a writer's intent or assumptions, and actually articulate those. And what I received an email a few days ago from one of our listeners, Betsy in Texas, and she sent me what I thought was a very, very informative document on the connection between argumentative writing and critical thinking. And the point of the article was that the research, I can't remember who wrote the article now, it was in Huffington Post, I believe. But the issue being raised was that there seems to be a loss of recognition or appreciation for what academic argumentation is all about, how to put together an argument, how to basically structure and defend a point of view. And part of that is because of the culture we live in, and a lot of it, I think, is attributable to the media. And I mentioned to Betsy that I'm thinking on Wednesday that this might be a good topic for us to really get into on Wednesday, would be the whole issue of argumentation and structure. Because what we're talking about here at the Virtual Center is understanding what the founders meant by what they said and what they wrote. What their thinking was, what the various options, interpretive options were. We're going to see this today in a Supreme Court case, in a couple of Supreme Court opinions on a particular case. But if you read Supreme Court decisions, it's very obvious that not everybody reads and thinks the same way. And different people see different things. They put the emphasis on different words, on different phrases, on different paragraphs, for example. And when they do that, the whole meaning of the particular document in question, or speech, or position paper, or whatever you want to call it, changes. And so part of critical thinking is the ability to know how to basically argue a point of view. And the article that Betsy sent me from Huffington Post was a position that basically suggested that the skill of putting together an argumentative piece of writing is pretty much missing from our schools, from our classrooms. And part of the reason for that is that I think is tied up with the media, that we have become so politically tuned in to particular point of views and particular ideologies that we have stopped communicating in an argumentative and learning kind of a way, and instead we tend to go for the jugular. We're looking to make points. We're looking to, as one article that I read made the comment, we're always looking for the slam dunk. We're looking for the argument or the position that's literally going to disarm the person or people who disagree with us. We're looking to win the competition. And the fact of the matter is, in doing argumentative writing and critical thinking that is so necessary to it, you never look for the slam dunk. Because learning itself is the process of argument and counter-argument and counter-counter-argument, if that makes sense. And basically the ability to respond to a counter-argument that a listener or somebody who disagrees with you makes. And the back and forth process of the exchange of ideas and perspectives among people is the way we learn. And we've lost that. We've lost that in favor of the competitive desire for the slam dunk. You know, we ultimately, how many times, and I'm thinking of the program that used to be on public broadcasting called Crossfire that was on for years. And it was a hit for years. But the whole idea was that there was an argument and a counter-argument, and that was it. But the assumption was that one side won and the other side lost, and that's the way our legal system is based. You know, that's the way our legal system functions as well. But the reality is, part of one's part of one's education is the process of how to do that, and how to engage in argumentative fashion, with the objective being not to win but to learn. To learn how other people think, to be sensitive to the ways that other people or other cultures look at a particular issue. And the more we do that, the more communication happens. And the more communication happens, the more we reach solutions rather than impasses. So I think Betsy's point was that this article on the absence of argumentative instructions to students in how to do argumentative writing is a major flaw in our education system, because it is making critical thinking very difficult. And basically, Betsy herself made the point, excuse me, in her email, that it is her perspective that students believe that opinion is fact. And once you make that once you assume that, if you assume that opinion is fact, and you assume that this is a free country, this is America, and my opinion is as good as your opinion, and the mere fact that I have it means you need to take it seriously because I have a right to it. I don't want to be crude or abrupt or anything else. But the fact of the matter is, the idea that every opinion is equal to every other opinion is garbage. Of course it's not. Of course there are opinions on particular issues that are much more substantive and much more valid than others. And part of the problem in our education system is nobody wants to point that out. Nobody wants to make, no teacher wants to make that point to students because they don't want to wound students. Well, the fact of the matter is, by not wounding students, we're creating a much worse problem. We're giving them the idea that if you think it, it's valid, it's fact. And it is not. And we're gonna be getting into this in the next day or maybe 2 days this week, because I think this is a very, very important issue. And again, the reason that it is valid here at the Virtual Center is because our entire mission, the whole reason we are here, is to try to enlarge and expand on the general population's understanding of the Constitution. Not only the document itself, but the conditions and the circumstances which produced it, the various positions and opinions on key elements of it, interpretations that the Supreme Court has made as the years have gone by and as circumstances have changed, and as different Supreme Court justices have found new ways of interpreting clauses and issues in the Constitution. One of the big issue today is privacy, and everybody knows there's nothing in the Constitution that guarantees anybody the right to privacy. But the fact of the matter is, most people, if you ask them, would contend that individual citizens ought to have a right to privacy, because technology has come so far, and we have come up with so many unique ways to invade people's privacy that some people already believe that we don't have it anymore at all. And of course, the stuff that's going on with the Edward Snowden release of information and those kinds of things about the NSA, and suggests that there's some validity to that. And so more and more people believe that what we've got to do is find a way to protect a little bit of privacy that people have left. And so, and I think most people, it doesn't matter whether you're liberal or conservative, I think most people would kind of go along with that to a certain point. So the point is that many people begin to look at the Constitution from the issue of individual privacy, when in fact in the 18th century that really wasn't, apparently, at least nobody that I know talked about it. So it wasn't a major consideration or a major fear. I don't think the founders, had a Ouija board or a crystal ball or anything, and they could anticipate what technology was going to do to the whole issue of individual privacy in this society or in this world. I don't think you could hold them to that. But the fact of the matter is, conditions changed, and as technology improved and as privacy became more and more vulnerable to technological invasion, then people began to look at the issue of privacy as something we were in danger of losing. And so even though it's not in the Constitution, many believe that it ought to be there. And some people are trying to find places within the Constitution which justify it. Many people point to the Ninth Amendment to the Bill of Rights, which suggests which says that the rights already articulated in the Constitution do not close the book on the subject. That there's a possibility that additional rights would come later, and indeed privacy is one. So the opinion that I really am asking for is it seems to me, is very, very critical to the mission of the Virtual Center here on Head On Radio Network. And that is basically what we're trying to do is expand understanding of the Constitution in all of its ramifications, in its interpretation, in its intent, in different perspectives and points of view on particular issues, trying to understand how particular things were looked at in the 18th century as opposed to today, etc. And what that means is we are looking to not only expand the understanding and appreciation of the Constitution and the founders, but part of that, it seems to me, is enhancing and improving on the whole idea of critical thinking. Getting people to think outside the box, to think critically, and not be dependent totally on being told what to think by somebody else, whether it's a teacher, whether it's a college professor, whether it's a textbook, or whether it's a curriculum committee at the county or state level. What we're looking for is people that can understand and reason and think and put together coherent arguments on a particular point of view or a particular position for themselves. That's what we're about. That's what the virtual center's about. That's what's been missing with the Constitution. Throughout our history, it seems to me, we have been, overwhelmed at different times by people who have taken it upon themselves to tell us what the founders meant by what they said. That's been our education system. That's what the textbooks do. The textbooks tell us what the meaning of particular issues and events are. And basically, what that does is not only insult the intelligence of the student, but it also deprives the student of the opportunity to come up with alternative explanations for particular events and issues. It denies the student the opportunity to experience creative thinking or critical thinking. It basically creates the impression that everything worth knowing is already known. Every position worth articulating has already been written. And what education is merely being able to get your hands on the right one at when the situation calls for it. And we know that that's not true. And we also know, I think, that that's been a major part of the problem I believe, in our education system today and in our society as a whole. One of the things that when I basically put this virtual center, came up with this idea of the virtual center. The idea is a virtual center for the study of the U.S. Constitution and civic responsibility. And civic responsibility. Because I think that part of our not really understanding fully the significance of the Constitution is not recognizing the kind of civic responsibility that goes along with it. When Benjamin Franklin said at the close of the Constitutional Convention, what have the founders, what has the convention given us? And his famous response upon leaving Convention Hall was, a republic if you can keep it. The implication is that a republic, in order to sustain it and grow it and strengthen it and benefit from it, a republic demands certain things from the citizenry. And we've lost that. Most people look at the Constitution from the perspective of rights, not responsibilities. And the key point is that if nobody fulfills their civic responsibilities to the community, to the nation, then rights are meaningless. And so the combination, the mix of rights and responsibilities is a key part of understanding the Constitution of the United States. The founders talked about that all the time. We've been through it. It's not like we've covered it. We'll be back to it over and over again. But there's no question. The founders talked about the idea of civic virtue. They went back to the classics. They looked at Athenian democracy. They looked at the Roman Republic. They looked at the nature of representation and the role of the representative and the link or the connection, if you will, between representative and citizen. And they debated. They argued back and forth for particular definitive positions on those key issues. Those are the kinds of things that I want to address here at the Virtual Center. Those are the kinds of things that I want students to be able to address in this course that we'll be offering here in the fall. And that's the reason that I want to link these students to the Virtual Center. And that's why I really believe that the website is going to be critical. The ability to post documents and the ability to talk about something that every one of us can look at while we're talking about it. And then if somebody wants to print off a hard copy, if you feel more comfortable with a piece of paper in your hand as opposed to looking at a computer screen, that's fine. But the fact of the matter is, it's going to create a little bit more predictability, a little bit more order, it seems to me, and it's going to give people an opportunity to make substantive contributions to the entire process. And I know I've gotten emails from people who said the reason I don't call, or the reason people don't call, is because they're really listening to the point of view. Well, the point that I want to make is what I'm giving is a point of view. It is not. I am not basically articulating fact at all. I'm basically saying this is what so-and-so said, and this is what he seemed to mean, or this is what she seemed to mean, or by it, or whatever, and then try to put that into the particular historical context within which it happened, and throw out possible interpretations. But these are interpretations. And the idea is, the whole idea of conversation, and I know Bob Kincaid all the time talks about the Head-On Radio Network, keep the conversation going. The whole idea of conversation is knowledge, is expanding understanding. That's the reason for dialogue, argument and counter-argument. My position, your position, my response to your position, your response to my response to your to the original position, et cetera, et cetera, et cetera. And the whole idea is that we all grow as a result. That's the ideal. And that goes all the way back to the ancients. That goes all the way back to the Greeks and the Romans. It goes all the way back to Plato and Aristotle. And the idea of learning. And the idea of the Socratic method, and the idea of Plato's dialogues in the Republic. And basically what Socrates is doing in these dialogues is counter-arguing. He's asking questions and setting up counter-arguments. And what he's doing in the process is not necessarily winning an argument. He's causing the person to change their minds by expanding their horizons and forcing them to think out of the box, because the box is something we create. And once people get out of the box and you ask the right questions, then fabulous things begin to happen. That's, it seems to me, what learning is about. That's what all of this is about. And so the last thing in this whole issue of argumentation, the last thing we really want is the slam dunk. Because the slam dunk ends the conversation. And the last thing we want to do is end the conversation. Because as long as the conversation continues and remains substantive, people continue to learn from it. Their horizons expand. Their perspective broadens. The depth with which they look and understand issues is enhanced, is increased. The only people that would be opposed to this would be people who don't want people to think, who are much more comfortable in telling people what to think than teaching people how to think for themselves. If you take it upon yourself to encourage people to think, then you surrender the right to have any control over what they think. You basically have to live with the result. And I would suggest to you that is a bargain, that is a gamble, that is a risk that our society has never been willing to take. We come up with all of these gimmicks in our education system. But the fact of the matter is, rarely do these things lead to creative ideas and new ideas. Rarely do they lead to constructive, substantive argument and expansion of perspectives and all the rest of it. Usually, It's a matter of finding new ways to teach the same things. And again, it's based on the premise that there's nothing new to be gained by this. You are a student. You are an uninformed student. The reason you're a student is because you don't know anything. Who would believe that as a student you would have something substantive to contribute to anything? Think about that. That's really the assumption that drives our education system. Plato made the comment and said, the educator is the person who has found the way to discover knowledge that's already within the human soul, that's already within us. The major things that people need to know, Plato said, are already within us. The role of the educator is to bring them out. The major flaw in education, Plato said, is to believe that education consists of introducing new information and new knowledge into the equation. The real education is to bring out the knowledge that's already there. And that's really the ball that I believe we've dropped. And I think that because of the technology that's available now, if we can use it in an effective way, and I think that's what the Virtual Center, has the promise of doing. Now, I'm not naive enough to believe that I alone or Bob or anybody else has the key to unlocking all the problems and all the negatives in our education system. I'm not that naive or that vain. But it seems to me that the technology that's available provides us an avenue, a way to reach more people with more substantive insight and innovation than we've ever been able to do before. It doesn't mean that the technology is the education any more than information is education. The education is what happens to the individual as a result of the technology or the information. If I give you a piece of factual information, there's no education taking place until you respond to it. And my role as a teacher is to find ways to get you to respond to it, and then I respond to your response. And that's the way we learn. But if you don't respond, I can't teach. If you don't respond, Socrates couldn't teach. And so that's kind of what we're about here. And that's why I want to connect these students to this program. I'm banking on the fact that with the website, we will begin to get people who are willing to call and offer points of view and exchange ideas and opinions with some of these young folks and get them to offer their opinions and exchange their points of view with you and really begin to get the conversation rolling. In other words, really create dialogue, trying to find strategies to make real conversation happen here at the Virtual Center. And I want your thinking, your ideas, your opinions as to what might make this work better. You listen not only to this program, but you've listened, I know you do, to Bob Kincaid's program and some of the other people that have been on the Hit On Radio Network over the months and years. Bob's been on for a number of years. And there have been some really, really good people on the Hit On Radio Network over that time. And so you as a regular listener, I'm guessing that most of you are regular listeners, and I think that's the value of this. If thinking people come back, then there must be something to it. And for years, thinking people have come back to the Hit On Radio Network. And I'm getting emails from those of you who choose to send me emails indicating that you are listening and you are reading and you are thinking, and that's really what this is all about. So, I respect your opinion. I solicit your opinions, your ideas, your suggestions. Obviously, this won't happen for a few more weeks. We're going to wait until after Labor Day. We decided that once the schools get the first few days out of the way and things stabilize and settle down in the school year, then what we're going to be doing is sending information home to parents, to the homes of students, and let them know that this course is available, and let them know that it's a college class, and that one half of the tuition is going to be paid by our local Rotary Club here, and the program is being co-sponsored by our local Chamber of Commerce. And so I think, I'm going to, in the letter that goes home to the parents, I'm just going to say straight up, this is a no-lose situation. There's no way you can lose, your youngster, your child can lose in this. Because the purpose is to find out what college is about, what college requires, and whether you can do it or not. And once you find out that you can do it, then you really have freedom, because you have some real choice. If you decide not to go, at least you know what it is you're not doing. Over the years, we've had people that label people and stereotype students, as mediocre and unmotivated and all of these other things. Troublemakers and behavior problems and attention deficit disorder people and all of these other things. In other words, all these reasons why you ought to think about doing something other than going to college. And the fact of the matter is, we live in a society, we live in a world where we need a lot more education than we're getting, and a lot of it has to be a little bit different than what we've gotten in the past. And so I really believe that this is a win-win situation for everybody. Because I'm not as instructor, as lead instructor in this program, I'm not looking at an opportunity to fail students that can't do it. I'm looking at this as an educational opportunity to show every student how to do it. If they choose not to do it, fine, that's their call. But at least they'll have the kind of information they need to make an informed and intelligent decision. And I don't think anybody can legitimately criticize that. I really believe, if you ask people, professional people today, in today's world, what caused you to major in business, or what caused you to major in sociology, or why did you major in English, or why didn't you major in chemistry, or why didn't you major in math or something? And you find out the reasons and the way people backed into their careers. It's amazing. It's absolutely amazing. A lot of, in my own case, how did you decide to major in, I didn't decide to major in history. Basically, it was decided for me, because everything else I tried I wasn't any good at. I guess, I don't know. But I couldn't do math. I struggled with math. I struggled with science. I didn't have really any technological expertise, and on and on and on. So by the process of elimination, it came down to, you're going to have to, if you want a college degree, you're going to have to major in this, or this. And so that's kind of the way I got into it, and I've talked to a lot of people that made the decisions in similar ways. Some of them didn't have any choice at all. Their parents did it. Their fathers are accountants. You're going to be an accountant. You're going to be a CPA, whatever. It's all, decided for you. You're going to be a doctor, an attorney, or whatever. But to try to give youngsters and families, parents, the information that they need to make an intelligent decision. I'm right now, and I don't want to go on with this forever, because I do want to get into something a little bit more substantive, but maybe it isn't any more substantive. Maybe this is the most substantive. I don't know. But I'm in conversation with a step-grandson who's a senior, is going into starting his senior year in high school this year. He's in the Midwest. And he's not here, but he's taken to calling me, and I love it. He's my wife's grandson. He's my step grandson. And the fact that he'll pick up the phone and call me to talk about taking the ACT tests or filling out applications to school or how to do the essays that they want in their applications or what to major in or how you find out which are the best schools in particular areas. And I'm flattered to death that he trusts me enough to ask me, and he feels comfortable enough to ask me. And so, I had a conversation with him yesterday, and what we talked about, I think it's important. He's looking at a number of different options, and he's looking at some really, really good schools with the idea of applying to them. And he's very tense about it. He's very nervous about it. And the reason that he's nervous, we talked about this, and this is what came out. The reason that he's nervous is because he's assuming that there's one institution out there that's the right one for him, and he's afraid he won't pick it. Which means he's afraid that he's going to make the wrong choice. It's like walking into the cereal aisle at the grocery store, and the whole right side of the aisle is lined up with every conceivable brand and kind of breakfast cereal that's imaginable. There's 180 different choices there. How do I know which is the best one? And so people are disarmed by choice, by the amount of choice they have. And it's stressful. And I think that this is part of the reason for so much stress in our society, is that we do have so many choices. If a lot of these things were decided for us ahead of time, if the options weren't there, then there wouldn't be any stress, and there'd be less stress involved in making the decision. So we talked about this yesterday, and finally he said, I think you're right. I think maybe I have a feeling that there's one institution out there that's perfect for me, and I'm afraid I won't see it. I won't choose it. The fact of the matter is, every institution that he talked about is a solid institution. It's a reputable institution. But the key to his success is not going to be the institution, it's going to be him. And whether his education is a success or not as much of a success is not going to be determined by the institution. It's going to be determined by the student. And if you choose to make your choice the right choice, it will be the right choice. Maybe there was another institution that would have met your needs better, but you won't even know it. But if you focus on making sure that the choice you make is the right choice, you'll do fine. Then you can't make a bad choice. And the more we talked about that, and I really think that that's part of our problem today, is that some people are hamstrung by choice, by freedom. It's like in grade school when they were writing cursive, and certain youngsters weren't mature enough; they couldn't stay within the lines. In art class, for example, they couldn't stay within the lines. Or in writing, you needed lined paper. Because if you had this blank paper with no lines on it, people tended not to, you had trouble writing across in straight lines. And so people felt the need for control, for limitations. And we've got so many choices. Just think about going into a restaurant. And you look at the menu, and there's 8 pages of options on the menu, and you finally pick one. But then when you are making your selection to the waitress, she's going to say, "What kind of dressing do you want on your salad? Do Do you want it on your salad or do you want it on the side? Do you want baked potato, mashed potato, hash browns, French fries? What? And the whole thing becomes one choice after another choice after another choice after another choice. And every one of them contains an element of stress. And by the time the waitress leaves with your choice, with your meal, your selection, you're pooped. And you say, well, I guess I did that. I completed that stressful experience. And I think it's amazing. I think it's really amazing. Because there's no question that if you ask people the definition of freedom, they'll say freedom is choice. And the real issue is, to what extent is freedom related to having some control over the choices? If somebody else presents the choices to you, is that freedom? Or is real freedom the opportunity to come up with your own? And if you believe the latter, if you believe that part of true freedom is in the ability to have some control over the options, then ask yourself, in our society, whether that's the kind of freedom we're preparing our kids with, we're preparing the citizens of tomorrow with. Or are we preparing them to make choices from a series of options from a menu that we present? And what we've done is we've made sure that all the options on there are safe. Doesn't matter which one you choose, because basically the ones that we would be afraid you would choose are not on there. We're not giving you that choice. So again, I really think that this is really an important experience, an important exercise, and I want these high school students to join us and to contribute and participate at the virtual center. And I want to provide them an opportunity to interact with you, the listener, and I want you, the listener, to have the opportunity to interact with them. And I think all of us will be better for the experience. So, to bring this issue to an end a lot later than it probably should have, I really do solicit your ideas and your input and your suggestions. If there's something that I could do or should do or say that will encourage students or encourage their parents or whatever even more to really take advantage of this, then I welcome it. I really do. Because I have tremendous respect for the people that listen to the Head On Radio Network. I not only have respect for the people that run it, but I have respect for the people that are regular participants in it. Because I think that they are thinking, creative, good, caring people. And those are the kinds of people that I want input from. So again, I solicit your ideas and your opinions. It's 11 minutes before the top of the hour. We'll be taking a 5-minute break at the top of the hour. That's a wonderful time if you want to call. If you want to email me with your idea or your suggestion or your comments, by all means, feel free to do that. My email address is waobrien906@gmail.com. And the phone number, again, area code 304-658-3333. Let's go back, if we can, to where we were a week ago. We were looking at progressivism. If you remember, we looked fairly extensively at Theodore Roosevelt's New Nationalism speech. We went through that speech pretty extensively. Not as extensively as we would have if it was posted on a message board. That's the point. I selected paragraphs that I thought people should at least address, think about. But I didn't read the whole document. I tried to, because it's a long document. If you print it out, it's like 11 pages. So I didn't want to take time here on the air to read 11 pages. But what I tried to do is read relevant paragraphs that raised issues that I thought, if people are really going to appreciate and understand progressivism and understand Theodore Roosevelt's approach to progressivism, then you can't do it without, unless you're at least familiar with this paragraph and this issue and that issue and the other. So I would say we probably ended up looking at probably 65 to 70% of the total document. And that's one of the reasons why I think it's such a rich document, because it's so full. It's hard to know what not to cover. It's so chock full of good stuff that you can't, you don't know what to skip. If you use a highlighter on the printed page, you end up highlighting the whole document, because everything seems important. And there aren't that many examples of writing that we come across that you can say that. So I believe the Roosevelt document is very rich. The other reason for that document being so important is because most experts in the field, most scholars on progressivism, will say that in order to understand progressivism, you really need to understand Theodore Roosevelt. Because not only was he the candidate of the Progressive Party, but he was probably the most visible, the most articulate, and the most outspoken and politically influential progressive in his time. So if you can get your arms around what Theodore Roosevelt meant by and thought about progressivism, you've pretty well got the topic. And again, Wilson is in the same category. Believe many of the same things. But and you can go online and look at Wilson's New Freedom speech, in which he talked about the issue of freedom. But again, what it comes down to is kind of minor nuances and differences between the two. Wilson is much more of an idealist. I think I mentioned this before, but at least in my experience, Wilson is a bit more of an idealist than is Roosevelt. And what I mean by that is, Wilson really believes in theory. Wilson really believes that, for example, that if you, meaning government, if you regulate bigness, corporate success, to the point that your goal is always to expand freedom, then you will know when to break up companies. When companies become so big that they inhibit freedom rather than encourage it, then it's time to break them up. And so Wilson's position was that bigness is badness, and government's role is to make sure that nothing becomes so big that it inhibits freedom. So when Wilson talked about new freedom, he was talking about a role for government which was primarily aimed at enhancing freedom for people in American society. That's really what free enterprise is about. That's what the capitalist system is about. That's what the Constitution and the Declaration of Independence were about. That's what the Enlightenment was about. That's what the scientific revolution was about. In other words, the whole ethic, if you will, of Western civilization is driven by this ideal. And Wilson believed that government's principal job was to basically make the ideal happen by just breaking up companies when they crossed the line and they became so big that they inhibited freedom rather than enhanced it. Roosevelt, on the other hand, was a little bit more of a realist. And Roosevelt believed that you couldn't, an ideal is an ideal. And you had to be a little bit realistic and a little bit down to earth. And so his idea is that, by definition, in an open society where people are free and where companies are free and people are free to experience profit, to be successful, then some people are going to become a lot more successful than other people. That's just the name of the game. And Roosevelt's position was, it's naive to believe that you penalize success by breaking up a company just because it's big. Roosevelt's thinking is the best thing that government could do is regulate bigness to make sure that bigness is goodness and not badness. If a company becomes so big that it potentially has so much power that it could inhibit freedom, then Roosevelt's position is you don't necessarily have to break it up. You just make sure that it behaves properly, that it does the right thing. So his argument is you need much more concentrated, focused regulation, government regulation and management. But his conclusion would be that it would be somewhat counterproductive to penalize success. That's interesting because that's exactly what Mitt Romney said in the last political campaign about Obama's position on taxes and big government and all the rest of it. That ultimately what we were doing was penalizing success. Part of his idea of success is you take the money and you basically stash it overseas so you don't pay taxes on it. And there's no sense of community responsibility or give back or the fact that the community as a whole has a right to anything. And that was Roosevelt's position. The community is the key. And it's wonderful when individuals can do well and be successful. But the key is your success is never your own. It's because of the circumstances and the conditions that are open and available to you, which is exactly the same thing that Barack Obama said in the campaign last year in 2012, in the election of 2012, when he made the very controversial statement, if you remember, about, if you're successful, you didn't do it alone, you had help. And if you remember, Mitt Romney and many of the other leading spokesmen for the Republican Party took issue with that. And it's based on the ideal of individual freedom on the one hand, but Roosevelt was much more aware of the mix, of the balance between individual responsibility and community rights. And I believe that that's a much more informed approach to progressivism. The other is a lot more idealistic, I think. And that's probably the major difference. So that's where we were last week, if you remember. We were looking at that issue of progressivism. One of the key issues that happens at the turn of the century, 1905, is a very, very prominent Supreme Court case called Lochner versus New York. It's a labor case. And it's about bakers. It's about bakery workers in the state of New York. And it becomes kind of a focal issue in the nation's bout or wrestling with the whole issue of progressivism. And so I'd like to spend the balance of our time today, after we take our break in a moment, I'd like to spend our time on the Lochner versus New York case because it's that important. And I think in it, we're not only going to look at the court's decision, it was a 5-4 decision. We're not only going to look at the court's decision, we're also going to look at a couple of the dissenting opinions. Because two of the justices who dissented in this decision were Oliver Wendell Holmes and Justice Harlan. Two of the most creative, thoughtful, incisive justices ever to sit on the Supreme Court of the United States. And their dissents are as informative as the court's decision. And that's one of the things we need to realize when you're trying to understand the Constitution, is that sometimes it's, the victory, the slam dunk is 5-4 decision by the court on a particular issue. But a lot of times there's much more information, there's much more to be learned by reading the dissents of the 4 than reading the opinions of the 5, if that makes sense. It's 1 minute after the hour. Let's pause and take a 5-minute break and get up and stretch and try to digest some of this, and then we'll come back and we'll look a little bit more specifically at Lochner versus New York. I'm Bill O'Brien. This is the Virtual Center for the Study of the Constitution. We'll be right back. Thank you, Bob, and welcome to the program. If you are just joining us, thank you for coming aboard. We welcome you. If you've been with us through the first hour, then we thank you for staying with us. In either case, your presence here makes us very happy, and I hope that you will find it worthwhile, worth your time, so that you will come back. And again, we look forward to hearing from you. The phone number, if you'd like to get on the air and offer your opinion or your ideas or your suggestions on what we're talking about today, the phone number is area code 304-658-3333. That's 304-658-3333. My email address, waobrien906 @gmail.com. waobrien906 @gmail.com. Well, just before we took our break at the top of the hour, we were talking about the very, very famous case of Lochner versus New York. And basically, the issues raised in Lochner, it seems to me, are so revealing and informative about progressivism and about the progressives' idea of government and government's proper role in a society. I mentioned earlier that it was a labor case. And basically, New York State passed a law regulating the hours that bakery workers could work. Obviously, this is not something that government took up on its own. This is obviously the result of lobbying and pressure on the part of bakers, of people who worked in the baking industry in New York. And the decision was made that the state of New York, had a responsibility, some responsibility, for the protection and the safety and the security and the health of its citizens. And so, in light of that, the state felt very, very comfortable in passing legislation regulating the hours that bakers could work. And basically, the argument was that it was not safe to work in a bakery for more than 60 hours a week. And obviously, the owners, the managers, the employers objected to this. And the issue ended up before the Supreme Court in the year 1905. And it became an issue about this emerging idea of government's responsibility to its citizens to be somewhat responsible for their safety and their protection and their good health and the working conditions and all the rest of it. And the employer's idea that this was state interference with something that ought to be between the employer and the employee, between management and workers. That it was overreach. It was a stretch for government to inject itself in contractual issues that involved only the company and its employees. That was the position that the employers took. And in 1905, in the case of Lochner versus New York, the Supreme Court, which was predominantly conservative at the time, as kind of like the Supreme Court we have today, in a 5-4 decision, struck down the New York law regulating the hours for bakery workers as a violation of the 14th Amendment to the Constitution. And the decision itself was issued, and again, it was a 5-4 decision, so 4 justices disagreed, and believed that the law was constitutional. So I want to share with you the court's decision, because based on the decision, you can see how the majority on the court, the 5, are interpreting the Constitution of the United States. This case was argued on February 23rd and 24th, 1905. It was decided on April 17th, 1905. And here's the court's decision. The general right to make a contract in relation to his business is part of the liberty protected by the 14th Amendment. And this includes the right to purchase and sell labor, except as controlled by the state in the legitimate exercise of its police power, period. That's the first sentence of the decision. It is loaded. So let's look at it. The general right to make a contract in relation to his business, we're talking about the owner of the bakery here, is part of the liberty protected by the 14th Amendment. No person shall be deprived of life, liberty, or property without due process of law. That's the 14th. That's in the 14th Amendment. It's also in the 5th Amendment. And you'll remember that the 5th Amendment was part of the Bill of Rights. It applied to the federal government. But the 14th Amendment applies to the states. And it was passed in 1866, right after the Civil War. And most people assumed that the person mentioned in the 14th Amendment was the African American, was the black American who had just been freed by the war. No person can be deprived of life, liberty, or property without due process of law. We know from previous things that at this time there was some question as to whether person included corporations. And that debate goes on. I'm sure we'll be back to that. So, basically, the court's position was that the employer's right to make a contract is part of the freedom, the liberty that is protected by the 14th Amendment. But then it says something else. And this includes the right to purchase and sell labor. To purchase and sell labor. The purchaser of labor is the employee, is the employer. The seller of labor is the worker, is the employee. So what this says is that the liberty protected by the 14th Amendment applies equally to employers and employees. Each of them is free under the 14th Amendment to make a contract with the other. provided except as controlled by the state in the legitimate exercise of its police power. The state has certain rights to protect the safety and security of the general population. So the rights of employers and employees to make contract do not supersede the right of the state to exercise its police power. In other words, these people are not free to enter into a contract which would threaten the safety of society, for example, by making bombs or drugs or something like that. In other words, freedom doesn't go that far. Freedom comes with responsibilities. But notice, not only does the employer have the liberty under the 14th Amendment, but so also does the worker, the employee. The implication here is that they are equal. They are equally free. Now, if you question that, if you say, it doesn't make sense to me that an individual worker has the same power to negotiate a contract as does the employer who employs 500 workers. So even though each side is free to enter into a contract, one side has much more power than the other. The court's not saying that. The court is denying that. The court is saying that in this particular situation, each side is free to make a contract. Then the court goes on. Liberty of contract relating to labor includes both parties to it. The one has as much right to purchase as the other to sell labor. So the court addresses the very issue that the liberty involved here belongs to both the employer and the employee. And the court says the freedom of contract relating to labor includes both parties to it. One has as much right to purchase labor as the other has to sell it. But again, the implication here is that they're equal. Next paragraph. The court says, there is no reasonable ground on the score of health for interfering with the liberty of the person or the right of free contract by determining the hours of labor in the occupation of a baker. So this is the court speaking directly to the industry itself. The court is saying there is no reasonable ground related to health, on the issue of health, that would give the state the right to interfere with the liberty of the person or the right of free contract by determining such things as the hours of labor in the occupation of a baker. In other words, the police power doesn't apply here, is what the court's saying, because there really are no health issues associated with the hours of labor in a bakery. The court is making a determination here. Nor can a law limiting such hours be justified as a health law to safeguard the public health or the health of the individuals following that occupation. So the court is denying the state's right to exercise its police power by making this law. The state is saying that working in a bakery does not pose the health issues that would justify the state coming in and enacting such a law under its right to exercise its police power. So the court effectively is denying the basis on which the law was made. It is denying the premise on which the original law was enacted. And now the court is giving information. Section 110 of the Labor Law of the State of New York, providing that no employees shall be required or permitted to work in bakeries more than 60 hours a week or 10 hours a day, is not a legitimate exercise of the police power of the state, the court says, but an unreasonable, unnecessary, and arbitrary interference with the right and liberty of the individual to contract in relation to labor, and as such, it is in conflict with and void under the federal Constitution. That's the thinking, that's the justices' thinking of the majority. The law is unconstitutional because the circumstances are not dangerous enough to the worker to warrant the interference of the state in making such a law. And once the court denies the health issue, then it has the right to say that the state making this law, since the health issues are not serious enough, that means that the law itself is unreasonable, unnecessary, and arbitrary interference with the rights and liberties of individuals to contract in relation to labor. So the court is finding for the owners of the bakeries against the workers by striking down this New York state law as a violation of the 14th Amendment Due Process Clause. And I'm not going to do this, but the rest of the decision itself is not that long. There are a couple more paragraphs here, but it more or less details the circumstances of where the case and where it started and what case it was, what court it was appealed to, and all the rest of it. But that's basically the decision, and that's the 5 justices who were in the majority signed on to that particular point of view. So the state, Lochner versus New York, strikes down a state law limiting the hours that people can work in bakeries to 60 hours a week and 10 hours a day max. The Supreme Court strikes the law down as unconstitutional because it violates the freedom of contract for both employer and employee under the 14th Amendment. Therefore, it's a violation of due process. That's the decision. That is a conservative court majority exercising or putting the weight of its argument on the side of individual freedom against the right of the state to promote the general welfare. The law itself, when the state made the law, it did so under the assumption that the working conditions in bakeries were dangerous enough and unhealthy enough that the state's use of the police power gave it the right to limit the hours in order to protect the safety of the workers. And the court is denying that. The court is denying the premise on which the law was passed, and therefore the court is ruling that the law becomes unreasonable, unnecessary, and arbitrary interference with the rights of free individuals to make contracts, both to buy labor and to sell labor. I mentioned that there were 4 dissents. The decision was 5-4. And there were 2 major dissents. One of them was written by Justice Oliver Wendell Holmes. This is his reason for voting against it. The other dissent was written by Justice Harlan, and 3 of the dissenters signed on to this opinion. So the 4 negatives, the 4 nays, were covered by these 2 dissents. Oliver Wendell Holmes explained his own nay, and Justice Harlan explained his nay as well as that of the 2 others in the minority. So I wanted to look at these, and I mentioned before the top of the hour when I mentioned these decisions that sometimes there's more or as much information, not necessarily more, but there's as much information in the dissents as there is in the original decisions. That's why it's very, very, I believe, very, very dangerous and I say this in terms of education, it's very, very dangerous to just look at what the court decided and why, which is what textbooks do. Because you don't get the benefit of the thinking that went into the decision either for or against the particular argument. And we know that most often the most important, the cases that get all the attention are really 9-0 decisions or 8-1 decisions. More often than not, they're 5-4 or 6-3 or something like that. And what that signifies is that there's a substantial philosophical difference of opinion on the court. And it is incomplete to ignore that and to just say the only thing that matters is the decision. I was privileged, I've mentioned this before, but I was privileged in graduate school to take a full year, 2-semester course on constitutional history of the United States from Stanley Cutler at the University of Wisconsin. And Dr. Cutler was probably as responsible for me in terms of what I did with my education after it as any. It was one of the, to me, it was one of the most meaningful classes I ever took in my life. I still remember, I mean, it was in 1966, 67, fall of 66, spring of 67. And I still remember particular issues. One of the cases that we're going to address here at the Virtual Center is the Charles River Bridge case. I think we probably have addressed it before, but maybe not in the details that it should, that we should. I had never heard of the Charles River Bridge case. I grew up in Boston. It was about Boston. But I had never heard of the case. When Stanley Cutler addressed that case in one of his lectures and told us that he had written a whole book on that one court decision about a case that I'd never even heard of, I was dumbfounded. I couldn't believe it. At the end of the class, after he got through talking about it, I realized that it was one of the most informative, insightful, and significant decisions that I had ever heard about. I still remember it. I read that book, and I believe that I probably learned more about interpreting the Constitution of the United States from that book than anything I've ever read, John Marshall or anybody else. And one of the things that Stanley Cutler did in that class was to expose us to dissenting opinions as well as majority opinions. And his argument, well, I can remember him saying that there were certain justices that would sometimes be in the minority on the court, and they were the brightest, most intelligent, most insightful legal minds that existed in the country at the time. And to ignore their opinions and their points of view and the way they thought because they were in the minority and they didn't win is shoddy scholarship. I remember him saying that. And so if you look at a textbook, some of the major textbooks in constitutional history, they will just mention case after case after case and say, this was the issue, this was the decision. This was the issue, this was the decision. This was the issue, this was the decision. Probably the case, the most famous case where this point can be made is the Dred Scott decision. We know what the decision was in Dred Scott. We'll be back to it again. But we know pretty well what it was. Dred Scott was a slave. And even though he had lived in free territory and then gone back into slave territory, the fact of the matter was, under the Constitution of the United States, changing where you are does not alter your status. In other words, you didn't become something different because you moved from a slave state to a free state or a free territory. The mere fact that that there was no slavery in that territory didn't mean that you ceased to be a slave because you were brought in it. You were property, the court said under Justice Taney's decision. Slaves were property. And to take away a person's slave because he lived in free territory for a time, to the court, to Justice Taney, was an unconscionable interference with a man's right to the sanctity of his own property. That was the decision. Most people know that. Most textbooks cover that. And then the court, then Justice Taney added an addendum to that. And basically he said, and this is logic. This is what we're talking about thinking out of the box and reaching logical conclusions. Justice Taney said, once you get there, once you reason that way, once you think that way, then you realize that the Missouri Compromise, which said, if you remember the Missouri Compromise of 1820, which said that no slavery would exist north of 3630, which was the southern border of Missouri, except for the state of Missouri. In other words, Missouri would be a slave state, but no other slave state would exist north of 3630, which was the southern border of Missouri. That meant that all the territories north of that line were free. There was to be no slavery in them. Justice Taney's reasoning in Dred Scott was that since slaves are property, that meant that the Missouri Compromise, which made it illegal for a man to bring his property north of 3630 except in Missouri, is unconstitutional. The Congress had no right to make such a law because it violated man's right to property under the Fifth Amendment. There's no 14th Amendment yet in 1857, so it violates the Fifth Amendment of due process. It takes away a man's property rights without due process. So in other words, because the court reasoned the way it did, that meant that the law that was passed doing it was unconstitutional. So it struck down the Missouri Compromise. And more than anything else, that brought on the conflict. The point that I'm making is that's all the textbooks talk about in Dred Scott. But let me make a point, and I'm not going to. I want to get back to Lochner, so I'm not going to go into this today. We'll go into it at another time. The whole series of debates by Stephen Douglas and Abraham Lincoln in 1857, the very famous Lincoln-Douglas debates, are based on the Dred Scott decision. If you think you know the Dred Scott decision and you do not know Abraham Lincoln's position, dissenting a position on that issue, his issue with the Supreme Court in that decision, then you are missing one of the most brilliant minds that ever existed. If you read Douglas, Douglas is rationalizing and expanding upon and explaining what the court did and why it did it, and Lincoln is taking issue with it. And that's what the Lincoln-Douglas debates are about. They're running for the Senate in Illinois. They're not running for president yet. This is 1857. They are running for the Senate in Illinois against each other. And the key issue is Dred Scott, the decision in Dred Scott, which the court had reached earlier. To deprive yourself of Abraham Lincoln's reasoning as to why the court was wrong in that decision is to really not understand the Dred Scott case. It's absolutely vital that we know what Lincoln said. Because ultimately what Lincoln said prevailed, because the war happened, the North won, and Lincoln was president, etc. So therefore, to listen to Lincoln and Lincoln's explanation as to why the court was wrong in Dred Scott is absolutely critical to understanding the whole issue. Those debates are incredibly important. So again, that's just an example. That's the most famous case. But that was the decision. So let's look at Justice Holmes. We're at 20 minutes after the hour. Let's look at Justice Oliver Wendell Holmes' dissent in Lochner. And he says, straight up, I regret sincerely that I am unable to agree with the judgment in this case, and that I think it my duty to express my dissent. In other words, I am so much in disagreement with this, and I'm going to write my own opinion, even though it's my own. It's a minority opinion. And this is what he says. And the point is, you can't deny this. But it gets lost because it's not the majority opinion. So let's look at what Justice Holmes said. This case is decided upon an economic theory which a large part of the country does not entertain. Think about that. This case, he says, is decided upon an economic theory which a large part of the country does not entertain, because a large part of the country believes that the law is legitimate, thinks that government does have the right and the responsibility to take care of citizens by passing laws regulating the workplace. So in denying that, Oliver Wendell Holmes is saying, in denying that, the court is actually espousing a theory which large numbers of people in this country don't subscribe to. He goes on, if it were a question whether I agreed with that theory, I should desire to study it further and long before making up my mind. But I do not conceive that to be my duty, he says. Because I strongly believe that my agreement or disagreement has nothing to do with the right of a majority to embody their opinions in law. What he is saying is that the majority, in striking down the state law in New York, in Lochner, in the Lochner decision, what the majority is doing is imposing its economic druthers on the nation. It is basically imposing 5-4 its economic theory against an opposing economic theory. And he said, whether I agree with the theory or whether I don't is not really the issue. If that was the issue, I'd have to go study it more and I'd have to do such and such. But as he says, the issue is not whether I agree or whether I disagree with the theory. The issue is, does the majority have the right to impose a theory on the nation, which means that their opinions become law? Then he goes on. It is settled by various decisions of this court that state constitutions and state laws may regulate life in many ways which we as legislators might think as injudicious, or, if you like, as tyrannical as this, and which equally with this interfere with the liberty to contract. He said there are decisions of court, there's plenty of decisions by the courts which establish the right of states and state constitutions to regulate the life of their citizens in ways which many people that sit on the legislatures might think is unwise, injudicious, he says, might think unwise or even tyrannical because they interfere with people's freedom to do what they want, the liberty to contract. Sunday laws and usury laws are ancient examples. A more modern one is the prohibition of lotteries. That's interesting because we don't prohibit them anymore, but we did in 1905. A modern one is the prohibition of lotteries. The liberty of the citizen to do as he likes, so long as he does not interfere with the liberty of others to do the same, which has been a shibboleth for some well-known writers, is interfered with by school laws, by the post office, by every state or municipal institution which takes his money for purposes thought desirable. So if you come down on the right of the citizen to have the freedom to make a contract, whether it's the employer or whether it's the employee, if that becomes your position, if that becomes the law, then what do we do about school laws, about states taxing citizens, taking their money for purposes that they decide what should be done with the money, whether the individual citizen likes it or not? You don't have a right to withhold your taxes because you don't like what the state's doing with your money, Holmes is suggesting here. The 14th Amendment, he says, does not enact Mr. Herbert Spencer's social statics. The 14th Amendment does not impose or legalize economic theory. He goes on and says, the other day, we, meaning the court, the other day we sustained the Massachusetts vaccination law. United States and state statutes and decisions cutting down the liberty to contract by way of combination are familiar to this court. Northern Securities Company versus United States. 2 years ago, that's where that decision was made. 2 years ago, we upheld the prohibition of sales of stock on margin or for future delivery in the Constitution of California. That case was Oates v. Parker. Decision sustaining an 8-hour law for minors is still recent. We passed a law saying that minors could not work more than 8 hours a day. That's law. Oliver Wendell, but a concept is not a particular economic theory, whether of paternalism and the organic relation of the citizen to the state or of laissez-faire. The purpose of a constitution is not to impose economic theory. It is made for people of fundamentally differing views, and the accident of our finding certain opinions natural and familiar or novel, and even shocking, ought not to conclude our judgment upon the question whether statutes embodying them conflict with the Constitution of the United States. Our job in interpreting the Constitution is not to operate according to an economic theory. Our job is to recognize that the purpose of a Constitution is to allow people with differing points of view to live there. And so, therefore, we've got to be very careful not to take the positions of some and impose them on others. That's not really what we do. Down. New York State regulating the bakery hours in Lochner versus New York. Understand this decision without reading this rationale by Justice Oliver Wendell Holmes. Basic saying in economic theory, and it's not what the 14th Amendment was about. Even though their role as judges is not to impose their philosophical preferences on everybody else. Their job is to basically determine what the law is and what the proper relationship is between government and its citizens, according to the Constitution of the United States. Oliver Wendell Holmes goes on. The decision is not much longer. There's one more paragraph. General propositions do not decide concrete cases, he says. The decision will depend on a judgment or intuition more subtle than any articulate major premise. But I think that the proposition is stated, but I think that the proposition just stated, if it is accepted, will carry us far toward the end. Every opinion tends to become a law. Every decision that the Supreme Court of the United States makes is to become, when it is held to the natural outcome of a dominant opinion, unless it can be said that a rational and fair man necessarily would admit that the statute proposed would infringe fundamental principles as they have been understood by the traditions of our people and our law. This is a statement for the living Constitution. This is Oliver Wendell Holmes as a liberal, is what we would call today a liberal. What he is saying is that every decision we make tends to become law. I think, he says, that the word liberty in the 14th Amendment is perverted. We do a disservice when we hold that this liberty runs counter to the dominant opinion in the society at the time. What the court's doing is going back in time to a period when people believed in the sanctity of private contracts, with no alternative. And what he's saying is the conditions today in the United States in 1905 are such that we would be violating our responsibility as government, as representatives of the people, if we adhered to ancient opinions and philosophies which no longer have relevance in the world. And that's what he's suggesting that the court did in this case. The court is taking a position contrary to what he says is the natural outcome of a dominant opinion, unless we can conclude that a rational and fair man would admit that the statute proposed infringes fundamental principles that have been understood throughout, by traditions of our peoples and our law. In other words, if a fair, objective, unbiased person could honestly say that this law violates traditions and fundamental principles that are critical to our nation, then I'd buy that. It does not need research, he says, to show that no such sweeping condemnation can be passed upon the statute before us. A reasonable man might think it a proper measure on the score of health. Men who might certainly could not pronounce unreasonable would uphold it as a first installment of a general regulation of the hours of work. Whether in the latter aspect it would be open to the charge of inequality, I think it unnecessary to discuss here. So he said a reasonable man might think the law is a proper measure when considering health. And he said, I also accept the fact that people that I would not call unreasonable would be afraid that this is the first step, the first installment in a general regulation of the hours of work. And he said, I can understand that. And then we get into the issues of inequality, but I don't think that's the issue here. What we'd be doing there, Holmes is implying, is we would be projecting into the future and say, because we don't like what this might lead to, therefore we're not going to do it. And he's saying the fact of the matter is we need to deal with the issues as they exist right now. And as they exist right now, he believes the state had the right to pass this law limiting the hours that people can work in bakeries, because to work more than that would be unsafe and would jeopardize their health. And his position is that's government's legitimate role, and that's why I dissent to this decision. You cannot understand the Lochner decision unless you read Holmes's dissent. Because in order to reach a conclusion that's meaningful, you got to basically be aware of both sides there. One of the things I would suggest is that what we're seeing here is that as the nation becomes more and more progressive, the majority of the court is becoming a little bit out of touch with the progressive thrust of what's happening in the nation. Now, one of the things that's going to happen is that because the court is striking down this state law, then what Roosevelt and Wilson begin to do in the election of 1912 is they're promoting a more visible, active role for the federal government. In other words, they're saying if we can't accomplish what we need to accomplish at the state level because the courts are going to rule against us, then we'll look to Congress to pass national regulations regulating the circumstances and the hours of work and labor and safety and all the rest of it. So the progressive movement, because of decisions like Lochner, moves from the local level, from the state level, to the national level. And that's what we were talking about the other day when we were talking about progressivism. So that's the Oliver Wendell Holmes dissent, and I think it's critical. Justice Harlan, in his dissent, he has two people sign on with him. Justice Harlan's dissent is quite a bit longer, and I'm not going to read the whole thing because we wouldn't have time. But what he does is go through a lot of decisions that the courts have made prior to that to defend his position. And basically, he begins with a discussion of precedent of what the courts already decided, and then he addresses his key argument. And he said, while this court has not attempted to mark the precise boundaries of what is called the police power of the state, the existence of the power has been uniformly recognized both by the federal and by the state courts. All cases agree that this power extends at least to the protection of the lives, the health, and the safety of the public against the injurious exercise by any citizens of his own right. So basically what Harlan's approach is in his dissent is to address the issue of the state's police power. And then he goes through a series of cases and points out that the courts in the past have validated, have supported the state's right to exercise a police power. And he uses an example. He said, in Patterson versus Kentucky, after referring to the general principle that rights given by the Constitution cannot be impaired by state legislation of any kind, this court said the following, quote, if this court has nevertheless, this court has nevertheless, with marked distinctness and uniformity, recognized the necessity, growing out of the fundamental conditions of civil society, of upholding state police regulations which were enacted in good faith and had appropriate and direct connection with the protection to life, health, and property, which each state owes to her citizens, unquote. So what Justice Harlan is doing, he's going back to a previous case, the case of Patterson versus Kentucky, and he's basically quoting from that decision. And basically what he's doing is upholding the right of the state to act when the life, health, and property of its citizens are apparently in jeopardy. So Justice Harlan is taking issue with the court's rejection of the idea that that this bakery law is a health issue. He's arguing that it is. And then he goes on and cites another case, which is Barber versus Connolly, and he quotes this about the 14th Amendment. I think this is very significant. But neither the 14th Amendment, broad and comprehensive as it is, nor any other amendment was designed to interfere with the power of the state, sometimes termed its police power, to prescribe regulations to promote the health, peace, morals, education, and good order of the people, unquote. So what Justice Harlan is taking is the alternative. He is denying the court, the majority's opinion, that this is a health issue. And he is reinforcing and showing by precedent that the court has traditionally upheld the rights of the state to exercise police power, to promote the health, peace, morals, education, and good order of the people. So if you impose, as Oliver Wendell Holmes said, if you impose an economic theory on society and it contradicts the state's right to do all of these things under the Constitution, then, according to Oliver Wendell Holmes, you are imposing an economic theory on society that doesn't belong there. And then Harlan says, speaking generally, the state, in the exercise of its powers, may not unduly interfere with the right of the citizen to enter into contracts that may be necessary and essential to the enjoyment of the inherent rights belonging to everyone, among which rights is the right to be free in the enjoyment of all his faculties, to be free to use them in all lawful ways, to live and work where he will, to earn his livelihood by any lawful calling, to pursue any livelihood or avocation. And this is quoted from the case of Allgaier versus Louisiana. So what he's doing is he's going back to precedents of previous court decisions. And he's basically driving home the argument that the police power and the responsibilities of government to protect the peace and safety and health and security and morals and education and order of its people cannot be infringed upon. And he's quoting from previous decisions to support this. I think this quote is incredibly important. Among the rights, the state may not interfere with the right of citizens to enter into contracts that may be necessary and essential to the enjoyment of the inherent rights belonging to everyone. In other words, everyone has got certain rights. And no contract, even though people are free to enter into contracts, no contract to infringe on people's rights. And among those rights is the right, and this is the quote, the right to be free in the enjoyment of all his faculties, to be free to use them in all lawful ways, to live and work where he will, to earn his livelihood by any lawful calling, to pursue any livelihood or avocation. This, Justice Harlan said, was declared in Allgaier versus Louisiana. But in that same case, it was conceded that the right to contract in relations to persons and property or to do business within a state may be regulated and sometimes prohibited when the contracts or business conflict with the policy of the state as contained in its statutes. In other words, even though the liberty of contract is guaranteed, the Allgaier decision made very clear that the right to contract cannot violate the right of the state to carry out its responsibilities to its own citizens. And then he quotes from another decision, Holden versus Hardy, which is the same one. So what Harlan is doing is he's upholding the rights of the state to exercise its police power. And he said, while this court has held, and he names a couple of cases, while this court has held that the police power cannot be put forward as an excuse for oppressive and unjust legislation, it may be lawfully resorted to for the purpose of preserving the public health, safety, or morals, or the abatement of public nuisances, and a law's discretion is necessary for the interests. In other words, this decision in Lochner infringes upon the legitimate rights of the states to exercise their police powers for the protection of the health, security, peace, stability of their own citizens. In other words, what he's saying is on the legislature out for the welfare of their own citizens. Therefore, I cannot sign on. We have reached the end of our program, and I apologize. I lost track of time, and I apologize. This is Bill O'Brien. Thank you for tuning in. We'll be back tomorrow.